Hello friends, in the series on the income tax cases, today we will discuss a very important case which talks about the time which should be given to the assessee for giving its submissions in response to the notices under section 142 subsection 1. The present issue has been highlighted or has been decided by the Karnataka High Court in the case of Doreswamaiah, Sureshbabu versus National Faceless Assessment Center and another. And this case has been reported in 460 ITR at page number 429. The matter has been decided by Karnataka High Court and the date of the judgment is 19th July 2023. The present case relates to the assessment year 17-18. In the present case, the first notice under section 142 subsection 1 has been sent to the assessee on 10th March 2022 for giving the submissions by the assessee on 14th March 2022. The time given in this notice was practically 11th March, 12th March, 13th March and 14th March, total 4 days. Although the assessee filed the reply to this notice, even then the assessing officer issued notice under section 144, that is for the best judgment assessment, which is given in those cases where the assessee do not comply with the notices or do not provide the details to the assessing officer. Although the assessee has provided the details, even then section 144 notice was issued to the assessee, and this time the notice was issued dated 23rd March 2022 to give the reply on 26th March 2022. If the days are counted, then practically in this case 24th March, 25th March and 26th March, only 3 days were given. Next thing in this case was that the notices were issued to the assessee on some email ID which was not related to the assessee, although the assessee has updated his email ID and that was confirmed by the revenue that the assessee has updated the email ID. Even then, the notices were not issued to the assessee on the email ID which was updated by the assessee. In spite of giving the reply by the assessee to the first notice, the best judgment assessment under section 147 read with section 144 was done. The assessee filed the writ petition for this assessment order in the Karnataka High Court, and the submission of the assessee was on the ground that there is a standard operating procedure issued by the department dated 19th November 2020. The clause B of that standard operating procedure says that the first section 142 subsection 1 notice should be given to the assessee by giving at least 15 days time to the assessee, and subsequent notices can be issued to the notices to reply within 7 days. But in the present case, in both the notices, the time which was given to the assessee was less than 7 days. Although in that circular, in that standard operating procedure, it is mentioned that keeping in view the limitation period, this time period should be adhered to. Since in the present case, there was no concern as far as the limitation period was concerned, so the court said that if the revenue has given the proper time to the assessee to give its reply, then it may happen that the assessee has given the submissions properly and there would have been no need to pass the best judgment assessment. Apart from that, the court said that there is no denying the fact that the notices has been issued on an email ID which was not related to the assessee. So the court inclined to quash the assessment proceedings, and at the same time the Karnataka High Court remanded back the matter to the assessing officer to give the proper time to the assessee. Friends, it is a very welcome decision by the Honorable Karnataka High Court, and generally when the principle of natural justice is not followed, all the courts are giving relief to the assessees. But as an advocate, as an assessee, my point is that with due regard to all the high courts, that the cases in which the procedures are not followed, the judicial decisions are not followed, the act is not followed. So in those cases, the matter should not be remanded, but they should be declared as null and void, and no second opportunity should be given to the assessing officers, because it is presumed that the assessing officers should have the complete knowledge of the procedures, so they should not be given the liberty. At the end of this video, once again I am repeating the name of the case. The name of the case is Doreswamaiah Sureshbabu versus National Faceless Assessment Center and another, and this case has been reported in 460 ITR at page number 429, and the matter has been decided by Honorable Karnataka High Court, and the date of the judgment is 19th July 2023. Thank you, friends.